Hi, this is Dan Whitney with the Whitney Law Firm in Towson, Maryland. Today we're going to talk about the issue of spot delivery financing, also known as yo-yo financing, and exactly what it is and why it's such a problem for so many people. What yo-yo financing refers to is the practice of a dealer selling a car and delivering it to a customer, and the customer thinking that they've purchased it before financing has actually been approved by a third-party lender. So what typically happens when most people go to the dealership is either they are going to pay cash, like such as paying with a check. They have obtained a direct loan from a bank, which is where they go to the bank and they arrange to take a loan, and they'll bring a check, or perhaps the dealer can get direct payment from that financial institution for whatever the balance is after a down payment and any trade-in. Or what most people do is go to the dealership and speak with the finance manager, and the finance manager says, great news, I've got you a very low rate, no one else can beat it, we got it through Capital One or Westlake or whoever, and we'll take care of the financing. And they're not doing that because they're helpful. They're doing it because that's how they make money. Banks make a lot of money holding points on the interest from loans that they arrange, which are called indirect loans. So one thing that a lot of people don't realize is, let's say a finance manager says, great news, we've got you 6% on this loan. Well, that sounds great, but usually, if dealers are able to, they will hold points, and usually they hold up to about 2 points. That's the most that I usually see here in Maryland. And what that means is you are paying 2 points extra, so 6 instead of 4 of interest, and the dealer is either taking 100% or a large percentage on the profit of those 2 extra interest points that you're going to be paying over the life of the loan. And they make a ton of money that way. So it's not because they want to be helpful, it's because they want to make money. So what happens is, unless you have a high credit score and it's really easy to get you financed, what happens a lot is a finance manager will say, look, we've got you approved, but the bank hasn't quite finished the approval yet. We're going to need some proof of income, proof of your residency, some utility bills, whatever it may be. These are called stipulations that the bank is going to need to see in order to say, yes, we're going to approve your loan. Or the finance manager might just say, hey, you're approved, and not mention, by the way, there's other hoops that you're going to have to jump through or the bank is going to make you do. In any event, in Maryland, when financing is not fully approved by a third party at the time of sale, what has to be delivered to the customer is something called a conditional delivery notice. And this is the first component of the yo-yo part of the sale. It's a document where the dealer is required to provide it to the customer. The dealer has to sign, the customer has to sign. And basically what it says is, we're telling you that financing for your vehicle is subject to approval by a third-party lending institution, and if financing is not fully approved or not approved within 4 days of you taking delivery of the vehicle, we have to tell you by this notice of your statutory, meaning your legally required rights, that we need to send you a written notice telling you, hey, it's been 4 days, financing is not approved, and now guess what? You have the right to get out of this deal, to get your trade-in back, if any, to get your down payment back, if any, and to return this car to us within 2 days. And keep in mind, this is Maryland. All states are different. In other words, what has to be done is a notice at the time of sale saying financing is not approved, and then within 4 days of delivery, a notice that says, oh, now it's not approved, and you have the right to cancel the transaction, get your down payment back, get your trade back, and give us the car back, and go about your business. And the reason for the requirements that these notices be provided at the time of sale and then 4 days later is because legislators finally realized what a hellish experience it is for consumers who have bought a car, financing isn't fully approved, they've traded a car in, they've made a down payment, usually of a couple $1,000s, and then they get stuck in this purgatory where the deal is not totally financed. The lender's asking for perhaps more proof of this or more proof of that, or the dealer is asking. Financing isn't finalized. The consumer doesn't quite know what's going on. The process can drag out. I've seen it drag out for months on end, and there's essentially no finality. And what happens is the consumer gets stuck because, in the absence of the law that applies to the situation, the dealer will say, oh, and this is the yo-yo part where they throw it out and then they bring it back. Oh, financing hasn't been approved, but if you put another $1,000 down and we increase your interest a little bit, great news, we can get you approved. That's what you'd like to do, isn't it? And the consumer, without the benefit of the law applying, usually is going to have to say yes, because they've already gotten the car, their trade-in's gone, they've made their down payment, they don't know they can get their trade-in back, or get their down payment back if that's what the law allows in their state. And they're kind of stuck with whatever worse deal. It's never a better deal. And if it is, there's a reason for it. It's usually a worse deal to force the customer to stay in that vehicle. Now, I have had instances where there's an approval on a set of terms, but then the dealer will sell a car and it'll be a spot delivery, meaning that it's a conditional approval. But then they will say, oh, we couldn't get you approved at these terms, and here's actually some better terms. Well, they're not being good, they're not being helpful, they're not being considerate. What's happened is they've jammed too much junk in that loan, or the loan to value ratio is too high, or there's some kind of problem where the dealer usually has put too much money in the loan. They want to borrow too much from the bank for the consumer, and the bank says, wait, what? The car's worth 10 grand. Why would I give somebody a loan for 15,000? It's just too much. I'm not doing it. And so what the dealer then does is they'll say, oh, great news. We got a new loan for you. But what they'll do is then they'll take off maybe some of the extra aftermarket products. They might decrease the price if they need to in order to get the loan to value ratio to make sense to get the approval. And sometimes that can be beneficial, but what they often don't tell the consumer is actually, because the original proposed terms were not approved, you have the right to get your down payment back, get your trade-in back, and go about your business. They don't like to say that because they'd rather make the sale, even if it's not as profitable. They don't want to take that car back and have to sell it to somebody else. They just want to sell that car and move on. So it's actually not helpful when they do it. Now, what happens when dealers don't obey the law? Well, they get sued. But what also happens is sometimes what they'll do is this. Let's say a dealer is not complying with the law here in Maryland, which happens all day, every day, which is why we're busy. But let's say in a spot delivery, they get carried away and they sell somebody's trade-in before financing is approved on the loan. And eventually they'll have to call the customer and say, oh, we didn't get the original terms, but these other terms are approved and you need to keep the car and sign this deal. And the customer might say, well, I'd rather just undo this. This all doesn't seem right. I don't want to be involved with this anymore. You know, this is too much for me. I'm tired of all the back and forth. Give me my car back. I'm going to give you your car back. Give me my down payment back, and let's call it a day. And then the dealer says, well, actually, you have no other choice. Your car's gone. So you're stuck. Now you have to take this new loan, and the customer, the consumer usually ends up signing. But what is critical for consumers to understand is just because the contract gets signed, that's not the end of the game. That's just the beginning of the game. If the dealer was fraudulent and fraudulently induced you and deceived you into signing a contract and acted illegally and didn't tell you why they were doing what they were doing and how they've broken the law, you've got quite a few rights and you can fight back and get out of that bad deal. Now, in a case like that, I've had quite a few of them, and you can end up getting significant compensation for the trade-in that was gone, for what your payments increased otherwise over what your loan should have been, and there's all sorts of ways to figure out what your damages are in a spot delivery violation. But in a nutshell, the point is this. In a yo-yo sale or a conditional delivery, consumers have more rights when they realize, and don't just think you're stuck with this loan. If the dealer tries to tell you that, find an attorney. If it's here in Maryland, give my office a call. But otherwise, find a consumer rights attorney, or just simply do some of your research. AI is a great tool to research law most of the time, and you can really educate yourself and realize, hey, here's what the law is. Did they send me this notice or not? And what's very important is, at least in Maryland, if a dealer doesn't send those notices, then guess what? Let's say the bank doesn't approve the loan. The dealer now becomes the lien holder, and that's not what they want. They don't want to collect $600 a month for the next 84 months. They just want to get their check from the bank. Once they assign the contract to the bank sends them a check, and then they've gotten paid, and then they move on. What they don't want to do usually is just collect that money and have to chase the customer, or even just set up a payment plan, because most of them, except the large ones, are not set up for this. They don't want to collect the monthly payments. And so dealers do all sorts of illegal things to try and not have to assume the position of lien holder due to their spot delivery violations. They do all sorts of illegal things, including sometimes getting arrest warrants for the customers, saying that the customers have stolen a car. That'll be the subject of another video that's happened recently. But the point is, in a spot delivery, in a yo-yo sale, you have many legal rights, and you should remember that. And if it should have happened to you here in Maryland, give us a call. We'll be happy to speak with you. Thanks for watching. Take care.